And a very good afternoon to everybody who's joining me on this lovely Friday afternoon in my webinar on how to get your business ready for changes to the furlough scheme. I can see there are still quite a few attendees that are still trying to log on. Hopefully we will have success this week and everybody will be able to join us today. You know, unlike last week where we had a couple of technical difficulties. If we do have technical difficulties during the day, please do remember that we do record these webinars and we will be able to send it out to you. So if you need to nip off or if anything happens that you can't access the webinar, you know, be rest assured you will still get a recording of it together with all our sort of handouts that go with it. Today is going to be another jam-packed webinar. Every week I try and think I'm going to make these a little bit shorter, but I have so much knowledge and information to share with you, I find it quite difficult to stop. So I am going to try and go through this as comprehensively as I possibly can. I'm fully anticipating that halfway through my webinar I might get interrupted with these long-awaited changes from the Chancellor on the furlough scheme. I have to confess I was waiting for some updates to come through at 11:30 this morning. We are now at 3 o'clock. They still haven't come through. Anybody who was on one of my previous webinars will know that we got interrupted about 15 minutes in. So, you know, do bear with me. Again, a little red flag warning. Everything is as valid as what it is at the moment that I'm delivering this. On many occasions, we've had to sort of backtrack or change what we are saying simply because of the guidance that's come out. So again, thank you very much for everybody for joining me on today's webinar on how to get your business ready for the changes to the furlough scheme. It's Friday the 29th of May and I'm going to be with you between now and 4 o'clock. So again, my name is Angela Clay. I am the Managing Director for HR for UK, and my role as Managing Director is to I'm responsible for HR for UK's support that we provide to business owners, you know, by providing a professional legal HR service to all our clients and those who join me on our webinar. So I hear you asking, who are HR for UK? HR for UK is the leading provider of HR, employment law, payroll and pension, as well as health and safety services. We've got over 30 years of experience and we've got some fantastic 5-star reviews on our website. I would absolutely encourage you to go to our website, have a look at those 5-star reviews and see for yourself what our clients have got to say about us. So my vision not only in this crisis that we find ourselves in, but it has always been my passion and my vision to help businesses to come out of this crisis successfully by offering you clear, professional, practical advice and that all-important support afterwards. So in today's session, I'm going to try and break it down into 3 big chunks. The first session is to how to prepare your workplace to meet health and safety requirements for staff, dealing with reluctant staff members who perhaps don't want to return to work. And I'm just going to talk a little bit about health and safety dismissals. You know, how they may come about in the employment law, you know, remit. And of course, that most important is how we can keep you out of having to defend yourself in an employment tribunal after carrying out a dismissal. So again, a couple of pointers there. And then finally, I'm going to be having a look at assessing your business demands and adjusting staffing levels in light of you know, the coronavirus job retention scheme being wound down. We know it's been extended to the end of October, but we also know that there are some significant changes that we are anticipating from the 1st of August. So again, you know, what those changes in August look like. As I said, I've been waiting very patiently since 11:30 this morning, so I could share that with you, but please do be rest assured, as soon as we do know anything, we will share this with you. So these webinars are as helpful as you want them to be, so please, on the panel that you've got, please do pop in questions that you may have. I will try and have a look at them during the webinar, and hopefully we'll have some time at the end for a Q&A session. But if not, you know, we do collate the questions that do pop in during the session, and we do put that into a Q&A that gets sent out after the webinar along with this recording. So please do use the questions box to pop in those questions. And again, if you have any ideas about what you would like us to cover in future webinars, you know, please pop that in there, because, you know, it helps us to make sure that these sessions are good for you and what you are looking for, rather than what we think you are looking for. So your help and participation is always welcome, and we always do take requests seriously. Right, let's get on to the nitty-gritty on how to prepare your workplace to meet the health and safety requirements for your staff. Now, some of you have been on these webinars before, so there might be a repeat of certain things, but as always, there's always more information coming to light. So, you know, just bear with me if you feel like I'm repeating myself, but I guarantee you will come away from these sessions having learned something a little bit new. So the government guidance has, you know, already stated very clearly that organisations are required to carry out a COVID-19 risk assessment before you mobilise your workforce back into the workplace. So for organisations with more than 5 employees, risk assessments must be documented. For organisations with more than 50 employees, you are required to publish your risk assessments. On your website is normally the best place to do that. Do bear in mind that failure to carry out a well thought out risk assessment could leave you open to not only regulatory sanctions, but it could even open you up to criminal sanctions. So it's really, really important to take the risk assessment and your health and safety obligations very seriously. The government has recently issued some guidance, 5 steps on how to make sure that you have a safe working environment. These steps are specific to COVID-19, but there are also other guidance that has been issued by the government, which has taken into account different work settings, different sectors, because of course you have a different set of risk assessments that need to be carried out when you are comparing, for example, a factory or a plant in comparison to your corner shop news agent. Likewise, a office environment will be very different to somebody who is perhaps on the road as a driver, so in a vehicle. So there are guidance that are quite specific to different sectors. We do anticipate more guidance to come out as the government releases releases and lifts the lockdown and allows more and more businesses to reopen. So do keep an eye out for all those guidances that come out. If anybody is looking for something specific, do get in contact with us. You know, you can email us at info@hrforuk.com, or you can get complete a contact us request through our website. Our website is www.hrforuk.com, and we will provide that to you. So do get in contact. So as I said, the very first step that you need to take before you remobilise your workforce is carrying out that risk assessment. As I said, this must be done before you've got your workforce coming in, and any risk assessment should be carried out in line with the HSE guidance. I am going to come to the HSE guidance in a minute, because I don't want to just drop it in and you're thinking, well, what do the guidance say? So I am going to come to that. So the risk assessment must be carried out in line with the HSE guidance. You must consult with your workers, and particularly if you've got a trade union recognised in your workplace, it is absolutely imperative, well, it's an obligation that you do consult with them, but it's good practice to even consult with employees, even if you don't have a recognised trade union. And the important bit about it is you must share the results with your workforce. As I said earlier, in certain circumstances, it must actually be published on your website. But again, it's good practice to share this so that your workforce know what the risk assessments you have carried out and what steps you're going to take to protect them. So let's have a look at what the HSE guidance says in relation to risk assessments. You are obliged by law to protect your employees. And the very minimum that you must do is identify what the risks that could cause injury or illness to your business. These are generally referred to as hazards. We're not talking about general hazards, we're talking about COVID-19. So we are specifically looking at what we can do about limiting that risks with COVID-19. You need to decide on how you are going to, how someone can be harmed by COVID-19. So again, when we look at the practical application of that, it is how is someone going to get infected, or how is the disease, the coronavirus, going to be transmitted. And then the big part of this is also about how are you going to eliminate that hazard? So how are you going to eliminate your employees or workers contracting COVID-19, the coronavirus, and how are you going to prevent the coronavirus from being transmitted? So carrying out the risk assessment is only one aspect of the overall process. So again, you know, it's not to be looked in isolation, it's to be looked at as an overall process that you need to carry out. For small to medium-sized organisations, perhaps the steps that you need to take are, I want to say, straightforward. They're quite relatively basic and straightforward. Of course, bigger organisations, bigger workforces, different workplaces will require a lot more. So as I said, the steps that you need to take to manage that risk management is a step-by-step process. And the starting point is to consider who is going to be responsible for this. So you can do it yourself if you're a small business, or you can appoint a competent person to help you. And what you would need to do is you'd need to identify the hazards. We already know that that's COVID-19. You need to assess the risks. So that is the catching of it and the transmission of it. You need to look at the controls. How are you going to control the transmission and the catching of COVID-19? You need to record your findings, and you need to keep those constantly under review. So we've already identified the hazard. As I said to you, we are talking specifically about COVID-19. So when you're looking about COVID-19 and you're looking about it in your business, have a look at how people work, what equipment is used. Have a look at, consider how COVID-19 or the coronavirus can actually come into your workplace. So how does it actually come in through the door? How can it be transmitted? So we know that people will be coming in, people will be traveling in. What is their exposure from home to work? You're then looking at your equipment. It might be keyboards, it might be plant material, it might be, you know, anything that you having that staff are going to be using. What have you already got in place in terms of protecting your staff? And what state is your premises in? So again, there are adjustments that you may need to make in terms of identifying those hazards. Do bear in mind and take into account non-routine operations. So for example, think about what happens when you have somebody coming in to, for example, carry out maintenance on the air conditioner. We're about to hit into summer, it's another glorious day. Air conditionings need maintenance, and is it a case of you know, somebody coming into your premises? So it's not just your workforce, it is the wider implications as well. So the public coming into your business are also perhaps a risk hazard, and that risk needs to be managed. So so the next step that you need to have a look at is assessing the risk. So decide how likely is it that the infection and the transmission is going to come into your workplace. We all know that the coronavirus is highly infectious, so that likelihood is probably quite high. So when you are looking at assessing that level of risk, decide who might be harmed and how might they be harmed. You've already got control mechanisms in place. Do they need to be improved? Do they need to be changed? What extra or further action do you need to take to get those control measures in place? Quite importantly is who's going to carry out the action. So you might know that you need to have hand sanitizers or paper towels in the washrooms. Who is actually going to source those? So again, making sure that, you know, it's great having this great big risk assessment put in place, but you also need to think about the action plan of implementing that risk assessment. And also take a view on when those actions need to be taken. So as I said, you know, before you have your workforce coming in, so I think it follows naturally that any action needs to be taken before your staff come back. The next thing that you need to have a look at is controlling those risks. So we've already identified that those risks do exist, but how are you going to control that? We already know, you need to look at what you are already doing, and you need to look at what else you need to do. And again, that will be viewed on a case-by-case basis, because you might have you know, certain parts of your business that might require certain things to be carried out. You might have other parts of your business where additional support might be needed. So again, we're looking at perhaps sneeze screens. I'm just going to talk about the basics here. Sanitizing gel, paper towels when you're washing hands. Of course, that's all important of washing of hands. So again, it's look at what you're already doing and what additional steps that you need to take. So other things that you might need to consider is perhaps you need to redesign the job. Perhaps there is another way that the job that currently gets carried out can be done. You might need to reorganize your workforce to reduce the exposure to the coronavirus. You might need to identify and implement practical measures to create a safe working environment. And you might also need to provide that protective personal equipment, your PPE, and making sure that actually, whilst you've implemented, that workers and employees are actually using it or wearing it, as the case may be. The important thing is, once you've got those measures in place, you need to actually implement them. So identify what you need to do and actually action them. It is impossible to eliminate the risk completely, but what you need to do is do everything reasonably and practically possible to protect all your staff. And this is a balancing act of assessing the level of risk, the measures that need to be put in place in terms of money, time, and the trouble. Now, you know, putting in COVID-19 coronavirus measures is going to be costly, but it has to be balanced in ensuring that you are doing everything reasonably practical possible to protect your workers. Of course, I talked about before is recording your findings. I've already mentioned that with 5 employees or more, you must record your findings, and these will include who might be susceptible for it and how it's going to be entering into your business, and what control measures you are putting in place. So again, those are what actions are you taking to protect the workforce. Don't rely on the paperwork alone. Paperwork is not going to get you out of it. Paperwork is only one element of it. It's the actual implementation of, you know, managing those risks. Of course, you know, a bit like my advice that I'm giving, it's a moving feast, which means that these measures must be reviewed. They must be reviewed regularly. And make sure that they are actually working. And they should be reviewed if government guidance is updated or new guidance is implemented. You should update your control measures if what you currently have isn't working, so if you see a spike, and if there are changes to your workplace. Many businesses are having to be agile to be able to change the way that they operate to still survive all of this. So again, the way your workplace was before the lockdown is perhaps different to what it's going to be when you come out of lockdown. So again, you know, everything at the moment feels like a bit of work in progress. So if there are changes to your workplace, constantly review those controls to make sure that you are still putting as much protection in place as possible. And of course, update your risk assessment. You know, if you are making those changes, make sure that the documentation that follows is also updated. So we've talked about this lovely risk assessment we have, and you will be able to download the our template risk assessment, but there are also different risk assessments available on the HSE website. They are templates, they are generic, they are there to provide examples of what you need to do, and it is an example of a record of who might be harmed, how they might be harmed, you know, what you are already doing to manage those controls and risks, what additional measures you need to put in place, who's going to be carrying out the work, and what action needs to be carried out by when. As I said, the templates, they are templates, and the examples that you are going to download either from our website or that you'll get as part of the package, or from the HSE website. Don't just think you can put your company logo on it and it will satisfy the law and it will protect your employees. You know, and I know you need to go a little bit further than that. So again, as I've already mentioned and identified, the government is issuing guidance on a daily basis. So do look out for those guidances and manage that risk in more detail. So that's what the HSE guidance says. So I'm now going to sort of go back and look at what the government guidance is. So we've talked about the COVID-19 risk assessment that must be carried out, and hopefully you've learned something there that you've got a to-do and that you need to go away and do it. So let's have a look at the second step that the government guidance has advised that business owners must carry out before mobilising the workforce back into work, and that's developing cleaning, hand washing and hygiene procedures. It should be clearly evident in your workplace by signage on the frequency required of hand washing and surfaces. You should really encourage employees and workers into your workplace on hand washing, and I'm going to just quickly touch on hand washing guidance in a moment. We shouldn't take it for granted that it's obvious, because it might not be obvious. Provide hand sanitizer around the workplace, not just in washrooms, have it scattered around in the workplace. And make sure that surfaces are regularly cleaned and disinfected. So this could be work surfaces, it could be communal areas such as kitchens, but don't forget areas that are frequently used. So for example, door handles. How many times do you need to go through in and out of a door? You've got great sanitizer either side of it, but what's happening in actually cleaning and sanitizing that door handle? Make sure that you have enhanced cleaning for busy work areas. It's not just where your workers are going to be working, but it is also areas where other people are going to be coming into your business. Make sure that you've got appropriate hand drying facilities. I've already talked before, if you have towels or toweling hand drying facilities, swap that out for paper towels so it can be thrown away. So as I said, washing hands might be quite obvious, but again, put signs up. The government has actually issued downloadable signs on how to actually wash your hands, and as good measure we're going to include it in the handout that's going to go out to you. So again, it is a government document, it's not ours, so again, you know, we do encourage you to make sure that that is there. Of course, washing hands properly, you know, removes viruses, which is part and parcel of containing that transmission of the coronavirus. Step 3 is to help people to work from home. So whilst the government is keen to get people back into work safely, there are also still sort of encouraging people to work from home if that is still possible. So again, you know, when we went into lockdown, it was a case of, I want to say, snatch and grab. It was probably quite close to that. It was take your equipment home, set up at home. But if people are going to be working from home more long term, you know, do make sure that you discuss home working arrangements, make sure that they have the right equipment, and make sure that they have the, you know, that you have got measures in place to communicate with those home workers. And it's really important to make sure that you look after their physical and mental well-being. Step 4, as part of the guidance, is maintaining that 2-meter social distancing where possible. So again, ways that you can implement this in the workplace is putting up signs as reminders to both workers and to visitors of social distancing. Avoid sharing workstations. You know, use floor tape or paint areas on the floor as a visual reminder of what that 2-meter distance looks like. You might want to implement one-way traffic through the workplace, and again, make changes on how you currently hold meetings. Again, if you're going to be having meetings, you know, maybe you want to change it by appointment only rather than people just dropping in. Or, of course, digital. You know, the digital platforms have really, you know, come into their own over the last, you know, 10 weeks or so. And step 5 of the government guidance is where people can't be 2 meters apart. You have to manage that risk, and that risk is that transmission. So again, some practical steps that you can put in place is, you know, consider whether the activity actually still needs to continue. You might need to make adjustments. Perhaps you don't need people to be doing a specific kind of activity for the business to continue operating. So again, assess those activities that need to continue. You know, have a look at the time involved. You know, do they have to be for the length of time that they are, or can it be shorter? Review it. Using screens or barriers to separate people from each other, and encouraging working side to side or back to back. At all costs, you should avoid the face-to-face contact. And where possible, you might want to sort of stagger start and finish times, and of course reduce the number of people who are actually in your workplace at any given time. So I think I've covered, you know, getting people back in. As I say, I've gone through that as a whistle-stop tour. I'm very conscious that we've got quite meaty bits still to get to. So let's move on very swiftly, where you've got reluctant staff returning to work. You've carried out your risk assessments, but addressing, you know, coronavirus, COVID-19 risks, and communicating the mitigation of all the measures to employees will go a long, long way of an employee being able to say, I'm reluctant to come back to work. So if you do the hard work of carrying out the risk assessment, putting all the measures in place and communicating it with your staff, the likelihood of them being able to turn around and say, I do not feel comfortable about coming back to work, will be significantly reduced. However, you are still going to get individuals who are not going to want to come to work. We should always still be bearing in mind that employers must plan how you're going to protect people who are at higher risk. So we know those that are clinically vulnerable. You might have those who are carers, and there are options. So perhaps there is the coronavirus job retention scheme that they may be able to stay on, or there are other measures, and I will have a look at that at the moment. And you know, I'm nervous about referring to the coronavirus scheme at the moment because we know that we've got those imminent changes coming in place. But at the moment, it is still an option, and unless and until we get told otherwise, you should still be using the coronavirus to protect those extremely high or critically vulnerable individuals. Nevertheless, you're still going to have individuals where they are going to have their concerns. Anybody who's raising concerns about returning to work, it is absolutely important for you to listen to those concerns and try and find a resolution. But the key thing is to keep a record of it. Even if you are just having a conversation, take the time to make a note of it, because those notes of how that conversation went will save you lots of time, because in passage of time, people's memories fade. So if you are going to be having discussions with an individual about not wanting to return to work, make sure you listen to those concerns, try and find a resolution, and make a note of those discussions. If the employee doesn't have reasonable grounds for the refusal to come to work, and as an employer, as a business, you have complied with your health and safety duties, with the current guidance, you must still act carefully and sensitively, balancing employee support, employee relations with the business needs. Okay, I can't stress enough the importance of that, because what you don't want is to inadvertently have reputational aspects that come into it. So listen to what your employees have to say, but also bear in mind how breaches of required social distancing and other health and safety policies that you've put in place are going to be dealt with. Because you might be having individuals coming into work, but they might flaunt those measures that you've put in place. So again, think very carefully about how you're going to treat those, what disciplinary procedures are going to be followed, and be clear about what sanctions you are going to be implementing. Take into account what those the different levels of severity are going to be, and make sure that the sanctions that are imposed are proportionate and that you are consistent throughout the way you are going to impose it. So let's delve a little bit deeper into individuals who are refusing to attend work for health and safety reasons. Now, the government is encouraging those that cannot work from home to go to work. Many employees in the UK still remain fearful about coming into work. And in fact, a recent survey indicated that 44% of employees are anxious about returning to work. So 44% is quite significant. But as an employee, there is a duty to put my teeth in. There is a duty to obey lawful and a reasonable instruction coming from their employer. So this is an implied term into every single contract of employment, that an employee will obey lawful and reasonable instructions given by their employer. Of course, requesting an employee to come back from work after furlough or unfurloughing them will be considered to be a lawful and reasonable instruction to their employee. So employees have protections. They have certain protections if they do refuse to attend the workplace because of a reasonable fear of serious and imminent danger. Now, I'm going to break that down into bite-sized chunks because it's quite important that when you are going to be dealing with health and safety and potential dismissals for refusal to return to work, these points are really important. So we've talked about giving a reasonable instruction for an employee to return to work, and we've also talked about employees who are anxious about returning to work and having a reasonable fear of an imminent danger. So we might find ourselves in an extraordinary situation where we have the employer having put in all those measures in place and requiring the employee to come to work, and on the other side we have an employee who feels that they are in reasonable danger of contracting the coronavirus. And this is going to result in a stalemate. There is going to be an impasse. And the best way to try and resolve that is to try and find an ad hoc solution. And this may be keeping workers on the furlough scheme. It may be finding other measures in place. But there are protections from detriments and dismissals, and this is specifically in the Employment Rights Act. It's Section 44 and Section 100, where employees are protected from detriments or dismissals if they leave or refuse to attend the workplace for health and safety reasons. So the protections only apply if an employee has actually left or has refused to return to work if they reasonably believe that there was a serious and imminent danger that they could not reasonably avoid, or that the employee took appropriate steps to protect themselves or others because they reasonably believe that they are in danger. So there's a couple of words that I'm really going to focus on, and as I said, they are important, and I'll delve deep into it. The employee must reasonably believe. That belief is a very low bar. There must be a serious and imminent danger. So again, what is that danger? It is the coronavirus. Is it serious? I think we already know that it is serious given how contagious it is. Is it imminent? Now that is quite an important thing to bear in mind, that the employee can't avoid. The other bit is that the employee has taken the appropriate steps to protect themselves or others because they reasonably believe. That is leaving work, because they themselves may have symptoms, or they might believe that one of their work colleagues has got symptoms. So again, those protections only apply if the employee has left work because they reasonably believe that there is a serious and imminent danger, or they took steps to protect themselves or others. So the protection is applied to all employees, but under EU law, it is extended to those who are also workers. So this will include agency workers, zero-hour workers, and also your gig economy work, your gig economy. So those who are self-employed but are classified as workers. Employees do not have to have qualifying service, so to get the protection. So there's no requirement to have 2 years service before they can bring a claim to an employment tribunal. This protection is given to them from day one. And you know, the scope of the protection is quite low, because the protection will apply if an employee has a reasonable belief that there is serious and imminent danger that they cannot reasonably avoid. So I've referred to the words reasonably believed, serious and imminent danger, and there's 3 key points that you need to consider when you are looking at that. So tribunals and the courts have already determined and interpreted that the danger is very broad. Now we're talking about coronavirus, we're talking about COVID-19, so we know that that danger exists. The employee does not even need to you know, invent a danger. We know for a fact that it does exist. So, but the danger can also arise from another employee. It could be relevant if an employee believes that a work colleague is symptomatic. You might have someone who is coughing and you know, not feeling very well, running a temperature. Without the test, we don't know whether they are symptomatic or not, but they might think, oh, actually, you know, there's a lot of coughing going over there, and you know, I feel that that is a danger. So again, that is a real scenario that may in fact happen. The second key point to consider is the question whether the employee's belief was reasonable. The fact that you may disagree with them on their assessment on whether the danger is reasonable is irrelevant. It is not the employer's assessment. It is the employee's belief whether they feel that they are at this, they're exposed to this serious imminent danger. If an employee's instruction to attend work was reasonable, and an employee is able to show that they have that reasonable fear, they will satisfy that requirement, that they genuinely believe that they are at risk. And employees can take steps to protect others. So again, they can refuse to come into work because they don't want to bring the virus into the workplace. They will get that protection. So it's not it's not confined just to other workers. It might be extended to taking steps to protecting their own family members. So again, it might be that actually these steps that I want to take is, I've got a vulnerable adult in my home. I've got caring responsibilities, and it's for those reasons why I want to not come into work. And I can feel all of you getting all prickly there, thinking, well, how are we going to get out of this? Because we're going to have this situation where employees are just not going to want to come to work, and there's nothing that we can do. You can still, there are still options. So what is still unclear is whether the danger is extended to the commute to the workplace, or whether the danger is just limited to the workplace, because you might have this absolute clinically pristine workplace, and an employee says, well, I've got to catch public transport to come into work. At the moment, it's unclear whether the danger is extended as far as that, or whether it is just limited to the workplace. So we'll keep an eye out on that one, and I promise to keep you updated. And do bear in mind is that what constitutes a serious and imminent danger to one employee will be very different to another employee. We all have different concepts of what that looks like. Some people might be not fazed by it, others might be really, really scared and afraid, and you can't compare one individual to the other. Everybody's circumstances are different. So again, you might have employees who have vulnerable or clinically vulnerable adults at home. Their position might be very different to someone who perhaps just has one other member in the home. So again, be sensitive about the individual circumstances when an employee comes to you with their concerns. Don't fob them off. Take their concerns seriously. When you are undertaking your risk assessments, employers must, and I can't stress this enough, take into account any potential discrimination, because discrimination law still applies. There is no excuse not to be mindful of potential discrimination. And one of the key things that have come out of this is the guidance that the government has issued in relation to extremely vulnerable and clinically and extremely vulnerable adults. You will need to be very mindful about that, because there are various protected characteristics that we're talking about here. We're talking about age, we're talking about disability, we're talking about pregnancy, but it's not necessarily just direct discrimination. We've also got to be mindful of indirect discrimination. So we need to be very, very careful of the big D word, discrimination. So, employees who suffer detriment because they have refused to return to work about a health and safety concern relating to their protected characteristic will give rise to a discrimination claim. So it's not just about looking at anything in isolation, it's looking at it a much broader when you are assessing whether the employee should or shouldn't be required to return to work. We also need to be mindful of those who are self-isolating, and if we need to sort of implement more stringent social distancing rules. If you cannot objectively justify the approach that you are taking, it is likely to be unlawful indirect discrimination against employees. Specific protections are available for disabled employees, and this might be action that is taken, and the discrimination will arise because they are shielding. So again, very, very careful. You do have, there is still that protection in place. What about employees with, caring responsibilities? The government is now encouraging workers to go back to work, yet many schools pupils aren't able to return. Employees who have caring responsibilities for children do not have a statutory right to refuse to attend to work because they have got caring responsibilities. They do not have a right to, employees do have a right to have a reasonable amount of time off for dependents, but of course this is unpaid. But what you do need to be mindful of is parental responsibilities as a general rule disproportionately fall to women, and an employer could face a claim of indirect discrimination if a policy has a negative impact on those with caring responsibilities. So be very, very careful and very mindful on what you are going to do. I'm just going to quickly do a whistle-top tour through 10 key points that employers and employees need to know about making sure that health and safety dismissals and detriments in light of COVID-19. Again, my advice would be, before you dismiss, take clear legal advice. We are here to help you and support you. Don't underestimate the expense and the stress of having to defend a claim when it can be prevented. So, if you are thinking about a dismissal, do contact us and get support and guidance. So let's just quickly have a look at those 10 key points. It's the employee's belief that matters, not your opinion. Danger is widely interpreted, and it's the actions of other employees that also count. Potential danger is not imminent, okay? It's not imminent danger, it's just got to be the potential danger. Employees themselves can take positive steps to protect themselves from the danger, even if it hurts your business. The danger doesn't have to be fellow workers. A key thing for employers, the damages or awards under Section 44 or 100 of the Employment Rights Act is unlimited. Okay, so there is no cap, and there is also no requirement for qualifying service. So big red flags should be coming out there. Individual rights are individual, so it's specific to an individual person. It's not collective, and workers may be protected as well as employees. So I've covered that. Employers must be very clear about why they are taking the action they are taking, so the dismissal. So I'll come back is, if you are going to be dismissing someone and you've ruled out any potential discrimination, be clear about why you are taking the action that you are taking. We are here to help you. We are here. We've got our coronavirus crisis package, to provide you with the support with this. Don't get it wrong. Don't take that chance. I can't stress that enough. So I'm really conscious of time, and I really want to get to the very meaty bits about this. And if it's okay with everybody, I will probably go over the hour mark, just to give you as much as what you can. But if you need to drop out, I'll be happy for you to do that. I haven't even looked at the questions. I don't even know how many questions there are. But if you can stay on, I'd encourage you to stay on. If you can't, don't worry, you are going to get a recording of this, and I'll be happy for you to fast forward until you get to this point, to continue hearing what I've got to say. So the final section that I want to have a look at is assessing your business demands and making adjustments, staffing level adjustments, in relation to getting your business, back in. So we know the coronavirus job retention scheme has been extended to the 31st of October, but we also know that we're going to get some guidance coming. But employers should start thinking about now. You should be thinking now what your workforce is going to look like, particularly how you are going to manage it once the end of the subsidised furlough scheme comes to place, where things start to go back to a more normal environment. There are so many options available to you when you are coming to the end of the furlough. You might want to be considering in having your own business furlough scheme in place. Obviously, you won't be able to claim back the 80% from the government, but there is nothing preventing you from carrying on with the scheme. Once the job retention scheme has been wound down. There are options for notice during furlough and the furlough period, redundancy payment rights during furlough. You could be looking at changing terms and conditions. So again, you might be scaling back, either to short-time working, layoff, or actually reducing hours. So again, there are lots of options, and I'm going to also talk quite a bit about dealing with redundancies during furlough. So I'm just going to touch very quickly on some general issues around furlough. The amount of notice that employers need to give their employees that they are required to come back into work, there is no prescribed notice period. But employers should be reasonable, and we would suggest that giving no less than 48 hours notice would be sufficient. But do go back to look at any communications that you've previously sent out, because you might have agreed something else. So before you get feathers ruffled by requiring somebody to come back into it, just double check, go back to see what communications went out. So in practice, most employers are going to start looking at introducing their return to work probably about the middle of July. We know that the scheme is going to carry on in its current form until the 31st of July. So it's not unreasonable to start looking at those notices to return to work from about the middle of July. You might want to do it before then, but that's give or take the timescales that we are looking at the moment. Again, how do you go about telling employees that they are no longer being furloughed? Again, there is no prescribed mechanism to bring employees back. It is good practice to communicate this to staff and to follow it up in writing, so you have got that audit trail. But you must remember that employees must be instructed that they need to come back to work. So it is that reasonable instruction piece I was talking about earlier. If employees are going to be coming back, they will need to rephrase that. Bearing in mind, when you sent employees off on furlough, that you instructed them not to do any work. So the likelihood of them checking work emails is probably zero. Are they going to be answering work phones if they've got one? Probably not. So again, you need to think about how are you going to be communicating that message to your staff, and how are you going to be communicating to staff what those next steps are. Some people will have been off work for over 10 weeks. I know last night we did the carers for 10 weeks. So some people have been out of the workplace for considerably longer than that. So having a return to work induction will be a very good starting point. So explaining to staff what that's going to look like is a good thing, because the workplace that they left all those weeks ago is not the same workplace that they are coming back to. Of course, not everybody will be coming back into work. It's not a case where, right, 31st of July, we need to get everybody back. Of course, you can still keep employees on furlough even when the government has ended the scheme. The coronavirus scheme was created to form an agreed layoff where there was no contractual provision in the contract. There is the possibility that employees will continue to agree to remain on furlough. It is an alternative to being made redundant. So don't underestimate the power of still being able to keep your staff for a longer period of time rather than just going straight into redundancies. You can keep employees on furlough with reduced terms. So again, this is a contractual change in contractual terms. This can be done whilst employees are on furlough. So again, make use of the furlough period in making these contractual changes whilst you are still getting the financial support in being able to do that. So once that that subsidy is withdrawn, we don't know how that's going to look just yet. But once we know that it is either, the subsidy is reduced or ultimately withdrawn, you are in a much stronger position because you may have already carried out those, changes to terms. You must, of course, get employee agreement. If you are going to be extending the furlough scheme, make sure that the current agreement that you have with them is still valid. You may need to issue a new or extend the current scheme. You need to be mindful of whether it's going to drop their pay below the 80%. So again, these are all options that are alternatives to redundancy. Don't forget, the contractual right to lay off. If you didn't have it in your contract and you haven't got an agreement that specifically refers to that, you do need to take additional steps, in terms of implementing that layoff. As I've said previously, short-time working and layoff, there are statutory provisions that come with that, which provides a right for employees who have been laid off or on short-time working who have been laid off for more than 4 consecutive weeks or 6 weeks in any 3-week period. This may trigger a statutory right for a redundancy payment. So again, just do bear that in mind when you are looking at that. If employees don't agree to an extension of furlough, look at other options, because there are other options. Furlough is not the only solution, and you might get some employees who are going to refuse to remain on furlough. If an employee has already provided their consent to be furloughed, they can't withdraw their consent. So once they've agreed to being furloughed, that consent is already given. They can't withdraw it. Do remember that if you are going to be extending or having a different type of furlough scheme, again, you need to get their agreement to that. We've talked about changing terms and conditions. We talked about reducing hours and pay for employees. This can be done during the furlough period whilst staff are on furlough leave. You must do it with agreement. And changing varying contracts of employment is a prescribed process. So again, it is a process that you need to go through. And if your organisation recognises a trade union, for collective bargaining purposes, you need to agree that change with them first, and there are specific prescribed processes that you need to go through. Of course, if there is no trade union, individual consent and consultation will need to be obtained, and of course you will need to evidence that in writing. So again, it's an all-important audit trail. Of course, if you've got the contractual right to impose short-time working, this is another option. So again, use what you've got. If you're not sure, get in contact with us and we will help and guide you through this. Don't try and do this on your own. You can reduce pay for employees and require them to do this. So let me rephrase that. You can reduce pay for employees carrying out the same work that they've done before. Again, this is a variation to contract. It is a prescribed process, again, and it's about that consulting, it's getting that agreement and having that audit trail. But it might be more difficult to encourage or get employees to agree this. I'm still working as hard as ever, but I'm going to get paid less. Make sure that you have the rationale behind why you want to do it, to make sure that employees understand the reasoning behind it. Because of course the alternative to that is being potentially made redundant. So getting some pay might be more attractive than getting no pay. So, if an employee refuses to go on those proposed changes, you cannot unilaterally force it through, and an employee can still refuse it. You do have an option. You can maybe rethink your strategy, or you can, force the change through. You can force the change through by imposing a dismissal on the existing terms and re-engaging on new terms. This doesn't come without risk, because of course there may be, it may give rise to a constructive unfair dismissal claim. Depending on how you've handled the situation will depend on how successful such a claim may be. So it's really, really important to make sure that it is handled correctly, appropriately, with the correct framework in place. But such dismissals can be fair, and we're all in difficult situations, and it may be a business necessity to make these big changes. So let's have a look at redundancy. You've looked at the other options that there are. So can redundancy be carried out during furlough, or should it be carried out after furlough? It is permissible to carry out a redundancy process while staff are still on furlough. It will depend on how many individuals are going to be made redundant. Will depend on the process that you need to follow. If you are going to be making more than 20 individuals redundant in a 90-day period, you have to follow different guidance. And again, that guidance will depend on whether you are making more than 100 employees redundant. So again, there are special rules that apply in terms of the consultation period before you serve that notice of the first person to be made redundant. So many employees will have been personally affected by the pandemic, and many may not want to return to work until much later. Some individuals will have perhaps child care issues with homeschooling or grandparents or other carers. You might have those who are shielding. There may be other considerations that you need to take into account. So can we make employees redundant whilst they are on furlough? And the answer to that is yes. So this is going to perhaps not sit very well with employees, because they may feel that actually being on furlough is being can be likened to sitting in the waiting room to become unemployed. So employers can make employees while they're on furlough. You may want to wait until the furlough scheme comes to an end before you make them redundant. The employee's rights will continue during any sort of furlough period. The coronavirus job retention scheme was put in place to try and prevent these redundancies, but we all know that it's the coronavirus job retention scheme is not sustainable, and there do need to be changes that may place. So in terms of whether going through the process of redundancy, is an employee working? If you are having to have employee reps for collective consultation, is that classified as working? No, it doesn't, because the individuals are not earning revenue or providing a service. Going through the consultation process, whether it's a collective or whether it's individual, does not require you to take the individuals out of furlough. They can remain on furlough while you are going through that consultation process. So you've gone through a consultation process and you are looking at notice. So it is permissible for an employee to be made redundant whilst they are on furlough leave, and an employee can be served notice while they are on furlough, and you can claim back the 80% of that wages. Now, notice pay in furlough is very complex, and it's not something I am going to cover here. I would strongly advise, if you are going to be serving notice and you want to know what that notice pay is going to look like, it will depend on so many different factors, and I'll probably spend the next 10-15 minutes just going through all of them. By the time I get to the end of it, you'll still be confused and not know which is going to apply. It is fact specific, so I would strongly advise getting advice on what furlough pay, what notice pay looks like in furlough. So again, it is very specific, and there are legal ramifications of the provisions in terms of notice pay. So do get back in contact with that. As I've already mentioned, you can reclaim the 80% through the furlough scheme. Depending on the circumstances, you may need to top that up so that they are getting their normal remuneration, but it won't apply in all circumstances. So again, be very careful. Most contracts, or some contracts at least, have a payment in lieu of notice clause. Payment in lieu of notice is discretionary. So again, if you do decide to exercise that payment in lieu of notice clause in furlough, you will not be able to claim that payment back through the scheme. So the best way to deal with that is actually to have an employee work their notice and stay on furlough leave during their notice period. So when we're having a look at statutory redundancy pay for employees who are on furlough, statutory redundancy pay is calculated in the normal way. There are no special circumstances or dispensation on how it's calculated. It is based on the number of years that the employee has been employed by the company, so it's completed years of service. It is the employee's age at the time, on the date of termination, and it is also the employee's weekly wage. Now, weekly wage for the purposes of redundancy is capped, and that current cap is £538 per week. So it is capped, but the normal rules in calculating statutory redundancy pay is unchanged. So let's have a look at, and I have touched on this very briefly, is looking at the consultation during furlough. So there's going to be a couple of things that I'm going to touch on to, focus your mind on it. Is carrying out individual and collective redundancy consultation can be carried out through furlough. As I've said before, it's not considered as work. It's not making money for the employer, and it's not providing a service, so it won't be considered at work. And that applies for individuals and for employee reps who are representing if there are more than 20 employees being made redundant. So wanting to collectively consult during the furlough period has its advantages. You've got the time and the framework to be able to do it. But it's a good time to think now about when and how you are going to be having that collective consultation. Now, when I'm talking about collective consultation, I'm talking about if you are making 20 or more employees redundancy. Of course, with anything less than 20 redundancies in a 90-day period, you can carry out individual consultation, and you don't need to think about the more prescribed consultation period. Collective consultation will depend on whether it's 20 or more or 100 or more. 20 or more, it's 30 days consultation before that first dismissal notice is issued, and 45 days or more if there are 100 or more employees that are going to be made redundant. But use this time on furlough to absorb part of the cost of that consultation, because of course we know that from the 1st of August there is going to be a cost element coming into businesses. So use the furlough period to its maximum to absorb a lot of those costs, including the notice period. So again, I know it sounds quite hard, but the scheme is there. Take advantage of it as best you can, because cash is king, and cash flow is really going to be important, particularly when you're going to have to start picking up the wage costs. So start putting a plan together. Previous webinars, if you're not too sure what to do go back into looking at my previous webinars where I have talked about what you need to start thinking about, what you need to start planning. So again, collective consultation, you must be done in good time. So even though we've got that minimum of 30 days and 45 days, that is the absolute minimum. Even with individual consultation, it's got to be meaningful. It's got to be proper, thorough consultation that you are carrying out. Don't think that, oh, you know, I've got 7 days, or I've got, you know, 7 days for an individual, by the way, is the absolute minimum. But when you're looking at 30 or 45 days, don't think, well, I've done enough now, because tribunals will look to see what you have actually done to make sure that, you know, the dismissal is fair. So the consultation must be appropriate. So if you've got a trade union, you must recognise them and you must involve them. Again, if you've got more than 20 employees and you don't recognise a trade union, you must involve employee representatives. So again, there must be, you know, trade union or employee representatives must be given specific information about the proposed redundancies. So as a minimum, you must be talking about ways to avoid redundancy, the ways and steps that you're going to take to avoid those dismissals, reducing the numbers of dismissals. What are you going to do to reduce that number? What mitigating consequences are you going to do? So what support are you going to be putting in place for those employees who are dismissed? And it's absolutely critical that every single meeting that you have does have minutes. Take notes, take notes, take notes. I can't stress that enough, because again, with passage of time, people forget what has been said and discussed. And of course, any consultation must be taken with a view to reaching an agreement. So again, let's have a look at some practical steps that you need to be mindful of when you are consulting, whether that's a collective consultation or an individual consultation, bearing in mind that a lot of people will be working remotely or will be on furlough. So, you know, have a look. You know, consultation is not going to be without challenge, but have a look at how you can do this. You know, certainly the guidance and in fact, case law already has shown that carrying out information and consultation obligations remotely is permissible. So we already know, even pre-COVID-19, that these can be done remotely. Make sure you use modern, you know, technology and hold meetings online. Make sure that employees have the information available to them before the meetings take place. Make sure that measures are put in place to ensure that employees can all log into the digital platform that you're using. Some platforms you have to actually download information beforehand. So again, it's really important to make sure that the support is in place, that employees have what they need to be able to participate in the consultation. And again, it applies to everybody, you know, whether it's a union rep, an employee representative, or whether it's an individual. All of these must be considered. The coronavirus has created a situation where perhaps you're not going to be able to comply with you know, the certain requirements. There is a special circumstances defence. I'm not going to go into that in great detail, but you know, it is very clear in case law that despite the coronavirus creating a situation where employers might find themselves in a difficult position to be able to consult, there is still a requirement that you must do everything that you possibly can to inform and consult, taking into account your particular circumstances. So once you've finished with consultation, what next? So that's that initial discussion. You know, individual consultation will still need to be required after that. So again, it is a process that needs to be carried out. And what you need to be thinking about now is what communications need to go out. Start thinking about how you're going to contact your employees and how you're going to send them the relevant paperwork. You know, as I said earlier, employees may not be logging into work emails. They may not have work phones. Make sure that you've got their home email addresses. Make sure that you've got their home mobile telephone numbers so that you can get in contact, and make sure that employees have access to a computer. You know, again, when you're going to be having these meetings, make sure that, you know, the individuals have a quiet place where they can have these meetings taking place, bearing in mind that many individuals will be, you know, at home with lots of other people around. So again, you know, planning is very, very important. The key thing to remember in redundancy situations is that there is no legal obligation for you as an employer to allow an employee to be accompanied by a friend or a family member or a work colleague. But you should be mindful about allowing this to happen in these circumstances. Do check with any discretionary measures that you may have in your own policies and procedures. Check to see whether actually it might be appropriate for you to bend the rules slightly, but check to see what you've got in place first. So just a quick couple of things. I'm going to wrap up with a couple of things to help you think about what to do next. Ensure that only those that are going to be affected with a potential redundancy are invited to the online meetings, because what you don't want is to scare those who aren't going to be affected. Ask employees who are going to attend a virtual meeting, make sure that they have got the appropriate equipment and software to be able to participate, and that they can have the meeting in a private, quiet room where they will not be disturbed. This information that's going to be shared with them is going to be, unwelcomed news, perhaps not surprising news, but it will be unwelcome and it will be bad news. Make sure when you are working on digital platforms that you ask everybody to speak clearly, so that you can hear, everybody can hear. Let the individuals ask questions, and if appropriate, confirm your understanding of what that question is. Explain that you'll be taking notes of the meeting and that will be shared afterwards, and remind them that they should actually be taking their own notes, and make sure that there is a clear record of what is actually being discussed. A key point right at the very beginning of the meeting, I should have said this first, ask employees to confirm that they are not making a recording of the meeting. So again, that you're using a mobile phone or some other means to record it. Again, if you have got concerns about this, remind them that they do not have a legal right to make a recording, and if they do that, you may view it as a potential case for gross misconduct, and you may want to remind them that COVID recording will be a breach of data protection in any event. So again, just these reminders and the tips. And again, throughout the meeting, just check that the employee is okay. Mental health issues are still very important, and again, if the meeting is going to go on for a long period of time, take some comfort breaks. Check whether they need a break, or there's anything that they need to do. So again, just be mindful on how you're going to be dealing with it. And the very big thing that comes across is, if you get it wrong in not complying with collective consultation, there is a protective award for up to 90 days pay for each affected employee to failure to meet the collective consultation requirements. So it is absolutely essential that you get it right. I can't stress that enough. In addition, employees with more than 2 years service, they have the right not to be unfairly dismissed. So although the dismissals will be for a business-related reason, and the obvious reason at the moment is the coronavirus, COVID-19 is likely to be a genuine redundancy situation where the dismissals are genuinely as a result of a redundancy. However, you must still have a fair and correct procedure that must be followed. So that includes a fair selection, individual consultation, and including considering alternatives to redundancy. So again, where an employee asserts their selection was discriminatory, again, there is no minimum requirement for service. So getting a redundancy right is so, so important, and I cannot stress that enough. So I was going to put a poll out, and actually on hindsight, I should have put it out right at the very beginning. But for those of you who are still with me, I'm glad to see I haven't lost too many people in the last sort of 20 minutes or so. But if you feel that joining me in a limited number of individuals, going through a case study with a workshop on carrying out the ultimate redundancy, do let me know, because what we may be looking at is perhaps putting on a specific webinar. It'll probably be paid for because I will be going through it on a case study. I will be giving you all the examples. I will be helping you to formulate a communication plan. I will be helping you with the letters, template letters. We will go through it as a workshop, so it'll be different to our usual webinars. If this is something that you are interested in, I'd love it if you could put it in the questions. If you are seeing this recording after the live webinar, please do drop it into an email. You can put it onto our contact form through our website, through the contact us. You can drop an email into, so I'll remind you of the website. It's www.hrforuk.com. Or you can drop us an email at info@hrforuk.com, or you can give us a call, and our telephone number is 01455 444 222. Ask to speak to me and I will help you. But of course, we have our coronavirus package. This is what the coronavirus package is designed for, is to give you that handheld personal support and guidance, not only with the templates, but giving you everything that you need in terms of making sure that you get it right. There's some key tips that I'll be able to share with you, on how to make sure you're not going to find yourself in a tribunal, and that is, of course, over and above going through a correct and fair process. So the coronavirus package is aimed at supporting you over 3 months. If it goes beyond 3 months, we will still continue to support you. You're not going to turn into a pumpkin and be left on your own, once that 3 months period is over. We will look to reduce costs, minimize the expenses that you are going to be facing in terms of employee costs. But importantly, we'll also be mindful of your own personal circumstances in terms of finance and costs involved. So we will really look under the hood of your business. We will have a look to see how we can help and support you going forward, bearing in mind those all-important costs, particularly with those changes to the furlough scheme. I haven't been given the heads up that we've had some changes while I've been talking to you, so I'm sure I've just been advised that it's going to definitely be at 5 o'clock, so look out for our update because it will be coming. So, don't do this on your own. Our coronavirus package is there to support you. This is both now and in the future. We want to make sure that your business is underpinned for any future HR decisions that need to be made. We are very cost effective when you are going to be comparing our costs against getting a consultant in to be able to help and support you. We are extremely cost effective against solicitors' costs. So apologies to any solicitors who are in there. So in the room, we are very cost effective to be able to provide you with a package that is suitable to your business. And of course, the cost of getting it wrong. I've talked about those awards. I've talked about the costs of defending an employment tribunal claim. It really is not worth it when help is available. So I'm not going to waffle on anymore. Just a quick recap of our contact details. You can get hold of us through our website, which is www.hrforuk.com. You can drop us an email, info@hrforuk.com, or you can contact us on 01455 444 222. We do have webinars every Friday between 3 and 4 p.m. Do let me know what you are interested in terms of topics for discussion, and we will really look into that to provide you with webinars that are what you want rather than what we do. Finally, just as a reminder, we are always here to help you. So I am about to turn into a pumpkin, but I just do have a couple of questions that have come in. I don't have time to go through all of them, but we have got some questions which I hopefully have answered. This question has come in from Nina. So Nina, thank you very much for taking the time in for sending your question in. Your question is, if a manager is furloughed and there are redundancies within her team, is she able to lead the consultation process with the support of HR? Absolutely she can, because it is not work, so she will be able to remain on furlough whilst still being supported and guided by HR in carrying out those redundancy consultations. So again, a couple of questions that have come in. A question today is, how to furlough staff. I think, depending on what comes out of furloughing, the coronavirus extension or any changes that are going to be made. At the moment, there's an indication that there may be a ban on employers putting new employees into the furlough scheme. So do look out for that, that particular aspect. At the moment, if you are going to be furloughing an individual, all you need to do is notify them that they are going to be furloughed. You should support this with a covering letter to explain to them what it means to be a furloughed worker. And again, you should be providing them with a furlough agreement. Both of those documents are downloadable from our website. So again, go onto our website, get the covering letter and get the furlough agreement and get that out. Again, bearing in mind that there is an indication that there is going to be a ban on introducing new workers into the furlough scheme. So I would strongly advise, if you're thinking of furloughing staff, do it now. I think, again, another question that has come in is what to do when staff don't want to come back to work. I think I covered that quite comprehensively, but again, as a starting point, try and get mutual agreement, try and understand the reasons why they don't want to return to work. Try and find a solution. Be very mindful of any discrimination. If all of that has been satisfied, there is no discrimination, either direct or indirect, you can see no reason why the individuals can't come back into work. It is unpaid, but it is absolutely imperative and important to make sure that you explore all options before you actually go through that. I'm definitely turning into a pumpkin. I can see engagement is dropping as people are leaving. Once again, thank you very much for your time. Have a fantastic weekend, and I hope to see you all back here next Friday. Thank you very much, and take care and stay safe.